Ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are
please,
being
nothing.
disrespectful.
You always
the
gonna
witness
find
may
some
step
reason
down.
to say somebody's being disruptive because they want the truth to be out there. Man, quit it. You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present. In Once
so
again,
we can
Mr.
open
Brooks
the door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly.
It's not a game. I don't take this as a game. That's what nobody. That's what nobody. You don't got to explain nothing to me.
My fourth from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Oh my gosh, this was the most bizarre trial I have ever seen, and I've covered a lot of trials in the courtroom. This was insane. The conclusion of this trial just happened today in regards to Darrell Brooks, the Waukesha Massacre killer, accused of murdering 6 people and injuring dozens of others, some seriously, when he plowed into a Christmas parade last November 2021. We are going to look through some of the craziest court video today and talk about this case. Let me know if you guys can hear me okay, because I'm trying the setup in my living room today. Checking your comments right now. Yes, we are live today, and you're not saying anything about my audio, so I think I'm good. Okay, guys, he's scaring the judge with his stare. There were wild outbursts, crying, taking off his clothes, insane scenes. But in the end, he even buttered up the jury towards the end, but nothing worked. He got convicted. The reason this case was so bizarre is that he decided to represent himself. He's not a lawyer, but he played lawyer throughout this entire trial, which made it very interesting, especially with his zero respect for the judge that he had. Here is where he chose to represent himself.
You are allowed to represent yourself in this case, sir. You will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
So that's what he did. He kicked out his attorneys. He did crazy things, even building a fort with boxes to block the judge from viewing him. I'm going to show you that video too. Before we get any further, shout out to the sponsor of my coverage. A shocking report reveals that burglaries are up in some cities by as high as 35% this year. Luckily, something as small as a camera in your front yard is proven to deter a would-be burglar. Unfortunately, however, less than 30% of homes have an effective security system, and criminals take advantage of that. I refuse to be a victim. That's why I install this camera security bulb. Cameras come with full color night vision, motion tracking, real-time alerts with the app, alarm functions, and bright light features, and two-way audio. The reason that these security cameras stick out from the rest is that they're the easiest camera to install that I've found. I just screw them into a socket like a normal light bulb. That's it. No wires or drilling a hole or climbing ladders like the traditional camera. Thousands of customers are safer with camera security bulbs installed. Try the camera security bulb risk-free for 30 days and save up to 65% off by clicking that link down in my description box, camerabulb.com. Lock in your discount and try it out. All right, guys. Let me show you how Darrell decided to build a fort to block himself from the judge.
No, I don't want to do that. Oh, you don't? I changed, hold on. 76. The 76 count. Just want to make. It says near Frame Park, so it is in there, but that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far, though.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
With as rude as Mr. Brooks was to the judge throughout the trial, she actually tried to cut him a break and give him some advantages. At the beginning, she was trying to get him to dress nice so that he'd appeal to the jury more, and he didn't want to do that at all initially. Watch this.
Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr.
Who
Brooks,
doesn't know that?
I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media.
Okay, so he did not want to change. They dismiss. He comes back. He still hasn't changed. He ends up creating an uproar and, refusing to let his shackles be taken off. Anyway, they ended up moving him to a different courtroom because he was creating too much chaos in that courtroom. So he takes his shirt off. Not only is he not putting professional clothes on, but then he goes shirtless.
Just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe.
Oh my word. Okay. So then he is not, he's his own lawyer and he's not reading the documents that they send him, or, they give him documents to look over, make a lawyer legal decision. He's not even reading.
I'm looking for a yes or no answer. If I'll unmute and provide that to me.
Go ahead. I didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial.
All right. So initially, after that horrible crime happened last November, plowing through the crowd, people look through Mr. Brooks's social media. And apparently, Candace Owens went on Fox and said he has got a lot of anti-white posts. He's clearly someone who's been radicalized by this BLM movement to hate white people. And there was speculation over whether he plowed through a Christmas parade to kill white people. Now, in the verdict today, there was nothing about it being a hate crime, but his victims were white. Let's take a look at who he killed.
The 6 people who were killed are Jane Coolidge, 8-year-old Jackson Sparks, Wilhelm Halspel, Tamara Durand, Leanna Owen, and Virginia Sorensen. Many, many more people were injured.
All right, he injured people of other races too. One of them was this Hispanic guy that he brought up to testify. So again, he's his own lawyer. So he is personally interrogating the people that he hit, but he's objecting to everything that his own witness says. It's so bizarre. Here it is.
I'm overruling it. It's relevant. It's not leading. The witness's answers may stand.
I mean, yeah, you overrule every objection.
And the jury will disregard the additional commentary made by Mr. Brooks at this time.
Judicial misconduct at its finest.
And which leg was that, sir?
Objection, action, answer.
Overruled. You may answer.
Voy a contestar la pregunta. El pie izquierdo. My left leg.
Did you have to have surgery on that leg?
Objection, bleeding.
Overruled.
Anulado. Sí. Yes.
Let's see what y'all
Just one?
Nada más una cirugía.
trying to get here.
Dos. Two.
That's not gonna work either.
Mr. Brooks, you are advised to stop with the commentary.
No, I'm gonna say what I want.
You called this witness. I'm going to take a break right now and excuse the jury and this witness.
That's not fair to the jury. They have a right to hear everything. Not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please, nothing.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present
and
in this
under
courtroom.
what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law,
Mr.
because
Brooks,
you can't do that.
I need to make a
By law, you
ruling.
can't do that,
I need to
and
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom.
He was kicked out of the courtroom so many times. But anyway, his baby mama gets pulled in this. He's trying to accuse his baby mama in this trial of being a bad mom. And the prosecution's saying, well, if anything, you're the reason because you impregnated her when she was underage. This was a crazy showdown.
Guilty in March of 2007 to that felony offense and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Oh my gosh. Okay, then there's another blowout.
It's not a game. I don't take this as a game. That's what nobody you don't gotta explain nothing to me. That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand.
But
and it's unfair. It's unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that? Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So,
And I understand.
I think, Your Honor, with all due respect, I think you should show some respect.
We're going to take a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care what you're talking about.
You're not rushing me to judgment. Okay, so then I got to show you this. I've just never seen a defendant treat the judge so disrespectfully. Look at this.
I don't have a problem with doing what you asked me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not going to work.
Okay, so the part where his stare scared the judge, I've got to show you this. It all started with the tone of the prosecutor, how the prosecutor said the defendant pissed him off and made him do this vicious stare down. But since when does a stare scare the judge? Watch
We
this.
should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how it said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I got one ear that work, and I heard that.
This is to benefit you so that you understand your witness has a prior record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice. This is the alleged record of Abel Lescott.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I believe he has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Oh my gosh. The viewers who are watching this thing, the comment section was basically saying, I hate this man with every fiber of my being. I want to show you how he tried to suck up to the jury before they made their decision on his fate. Oh, hold on. I think, is this it?
Objection, Your Honor. Why is something always funny?
Oh, this is another. Okay, I'll show you guys this one too. This was another funny.
Objection, Your Honor. Why is something always funny at that table? It would be the same thing. I take that as disrespect because they were allowed to say something, and I said under my breath that was disrespect.
I would direct both parties to avoid commentary.
Okay, well, can you do that, please, and admonish them? Because I'm always the one getting admonished.
Everyone,
I take that as disrespect too.
Sir, I'm good. Can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
all these
the
cameras
witness.
in here. Don't nobody
However,
see nothing.
I'm advising both parties to show
Man,
decorum
this is not fair.
and restraint, to be respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented.
Objection, Your Honor. Why is something always?
I was like, what is going on? Is this a movie? How is this real life? This is an actual trial of a horrible criminal who murdered 6 people. But this trial was insane. Okay, watch how he tried to suck up to the jury before they made their decision on his fate.
I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely, and I know, and I have faith, and I trust that you guys know what's right. Thank you for that. Thank you for taking pretty much a month and setting it to the side.
Oh my gosh, his suck up didn't work. They convicted him of murder. Let me just show you his reaction when his fate was decided here.
If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. Dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide?
You can see it just went on and on. He faced over 70 charges for plowing into all of those dozens of people that day in November last year. And it's interesting how calm he was once he learned his fate, given how wild and argumentative he was throughout the trial. Once it came down to it, he had no reaction, even when that guy in the crowd shouted, but basically burn in hell, you piece of S word. Looking at your comments here, it's good to see someone who does something like that locked away. Now, he had argued that it was a vehicle malfunction. He didn't mean to plow into those people. He said there was a recall on his Ford vehicle, and but when investigators checked the car, they found that it was working perfectly, and that was not the situation. So it was determined that it was intentional homicide. I'm looking at your comments. He thinks he's in a movie. Dude's been watching too much Law and Order. Yeah, I guess maybe he felt, look, I'm gonna lose anyway. I might as well create a show out of this whole thing. It was quite the show for sure. So I haven't heard his sentencing yet, but he has been found guilty. Typical abuser, mentally. He had initially said that he was, he pled not guilty due to mental issues initially, but then he real quick changed that and said, no, I'm mentally good to go. His mental state was tested and he was found to be competent to stand trial. So as wild as he seemed, and going shirtless and pacing back and forth, and when the judge put him in another room because he would not stop arguing, he's in there like through the window going like this the whole time, trying to get the judge's attention because she's got him on mute. It was an insane case, and it looked like maybe he was having a mental breakdown, but the test showed that he knew exactly what he was doing, that he was all mentally there. Checking your comments, but it's just a really interesting situation with the judge. I've never seen a judge be scared of a defendant's stare and dismiss court because she is scared of his stare. What is going on? Thanks for the super chat, JJ, super sticker. For some reason, it won't let me bring up what your sticker says until later. Thank you so much for the sticker. I appreciate the support, everybody. And we will see you guys tomorrow. And we are having a live Truth Bombs again this Friday with Natalie Denise coming back. So tune in for that for our Halloween Truth Bombs. You guys have a good one. We'll talk to you tomorrow.